doing well? My name is Ali Talai. I welcome you to this webinar. I'm hoping that I would be able to add some value to you today and talk about how to choose the right trustee for your trust. It becomes a really important decision, figuring out who's going to be the person that would sort of manage the trust and the estate and the assets that are inside of it. Before I get into this somewhat of a short webinar, let me introduce myself. My name is Ali Talai. I'm the CEO and I'm an attorney at law here at Talai Law Offices. My office is here in Woodland Hills. And beside having a law degree, I also have an advanced tax degree, NLM in taxation, a certificate in estate planning, and that really helps in some of the work that we do. We're only a estate planning law firm. We don't do anything else. We focus on estate planning, advanced estate tax planning, asset protection, probate, and trust administration. I host the weekly radio show on KIRN 670 AM at 9:30 in the morning. And I also have a real estate broker license and a mortgage broker license. All right. So if you're thinking you want to get to hear us more often, you could always subscribe and follow us on LinkedIn, on Instagram, on Facebook, and YouTube. This is some of the information here on this page. And let's get into our webinar today, trying to figure out how do you choose the right person as a trustee. And before I do that, I want to explain to you and share with you what is a trust. I mean, obviously, we want to figure out what the trust is before we could figure out and talk about how do you select the right trustee for it. A trust is an agreement between a grantor and a trustee. And then you may be thinking, well, who's a grantor? Who's a trustee? A grantor is the person that creates the trust. And to confuse us more, it seems like there are three other names that are used, all meaning the same thing: a grantor, settlor, trust maker, and trustor. All these four names refer back to the person that has created the trust. In most cases, you're the person who's creating the trust, and now you get this second person or second role in the trust, which is the trustee. And again, when you create the trust, in most cases, yourself, your spouse are the current trustees of the trust, and the trustee is really just the manager of the trust and would take care of what needs to be done. In a case where you're creating a trust, maybe a revocable living trust, and you're the grantor and you're also the trustee of the trust, you're doing exactly what you're doing now. So if you transfer real estate property, investment property, you're paying the property taxes, you're paying insurance, you're talking to tenants, and all the other stuff that you're doing now. Another way you could think of a trust is think of a red bucket. And you get this red bucket, you have your assets in there, you put your home, your bank account, your investment account, they all go in there. It's got a handle, and you as the trustee of the trust, you're holding on to the handle. Unfortunately, at the time you pass away, you're not going to be able to hold on to this handle anymore. And now the successor trustee that we've named in your trust, they'll be able to step in and hold on to the handle, so the assets that you place in this red bucket, they don't fall out. That's really another way that you could think of a trust. Trustee manages the accounts and the property. There are instructions in the trust that says what the trustee can do. Sometimes clients call and they think whoever they appoint as the trustee, he or she could just do whatever they want to do, and that is not the case. Trustee is bound by the trust agreement and what's written in there. Imagine if you worked at McDonald's and you were the manager, you could do a lot of things. You could manage the store, but you're not going to be able to sell the store or do different distributions to the owners. And all right, so let's talk about what is a trustee. Trustee is really a person that makes decision, handles all the matters that are related to the trust, may act when you're no longer able to run the trust. So this is the successor trustee. Again, like I mentioned, you're the current trustee. We have named people that are to serve as successor trustee, and you could have them serve at the time you're incapacitated and don't have the ability to serve. And at the same time, when we create the trust, we don't have to wait for something to happen in order for somebody to step in. I may say, you know what, I don't want to deal with any of these things. I'm going to name my son, my daughter, my spouse, or whoever I really want as the successor trustee now while I'm alive. So they could serve while we're alive and fully able to run these things if we want to. Let's talk about the type of trustee. So you have this initial trustee, which could also be referred to as the current trustee. And as I mentioned, that would be yourself or whoever the current trustee is. Then we get the successor trustee. This is a trustee that would step into the role at the time you're not able to be the trustee, or the trustee that is acting as the current trustee is not able to serve. We have trustees that act as the trustee for the entire trust. And then sometimes, to do better planning or for different reasons, the trust itself may have subsequent trust or continuing trust that are built into it. And we could have a different trustee for each sub-trust. For example, a common trust is that we would create a trust, a revocable living trust, let's say, and we create trust for our children within that trust. And the main reason we would do something like that is to provide our children with asset protection. So at the time they inherit the estate, they get their inheritance, instead of it being under their personal name, it's under this trust name. And if something happened down the road, they get in a lawsuit, they get in a divorce, or some other problem, bankruptcy, the assets that are placed inside of this subtrust, this continuing asset protection trust that I created for them, would be protected against lawsuit. It'll be much, much more difficult for a third party to gain access to it. And that's what those sub-trusts are. And then sometimes we have different trustees. Sometimes we could create and bifurcate the role of the trustee, and we could have distribution trustee. That would be the person that would be responsible to writing checks. And then we would also have trustee that would be the investment trustee. Now they'll make decisions as far as, do we sell a property? Where do we invest the assets? Those sort of things. All right, so now let's talk about trustee duties. One of the main duty that a trustee has is that they get to manage the property and the assets that are inside of the trust. Keep in mind, the owner of the asset is the trust. The person that is responsible to carry and do what needs to be done is the trustee. The trustee oversees the management of the investment. And that's realistically one of the main responsibility a trustee have. They have the responsibility to manage property and the assets of the trust. And the other responsibility they have is they got to keep the beneficiary informed. This is where so many times we have clients or lawsuits that arise, and it's really for lack of communication. As a trustee, you are in charge, but you have to act on behalf of the beneficiary, on their best interest. Trustee must constantly or periodically inform beneficiaries about the trust. They need to let the beneficiary know what the trust owns. How much does the trust have? What's the income it received? What expenses it paid? A lot of times, a lot of trusts require at least an annual accounting to be sent to the beneficiary. Again, as I mentioned, the fact that somebody is the trustee, or if you are selected as a successor trustee, in no shape or form, you are the owner and could do whatever you want to do. You're serving as a fiduciary, and you have responsibility to make sure you keep beneficiaries informed. The other thing is, as a trustee, you're acting as a point person, meaning that you have the responsibility to file tax returns. When I am alive and I create a trust, in many cases, these trusts could be drafted in such a way that when I, as the grantor, am alive, I will file tax returns, but the income that this trust is generating, all that income could be reported on my tax return. They call these kind of trusts the grantor trust. However, at the time the person passes away, the grantor passes away, IRS requires the trust to file a tax return. Again, in most cases, unless the trust is written as a 678 trust. So as a trustee, you got to file tax returns. You have to participate if there is any lawsuits and make sure you defend the assets of the trust, and then answer questions about the trust. If there is, again, many cases, lawsuits and things like that, then you are the person that would have to be involved. Now we look to see what we want to look for in a trustee, right? So we want to make sure they have the ability to ask for help. It's key. I mean, obviously, you're watching this video, you're going to hire us or you hire an attorney to draft the trust. You are not personally writing the trust. You're hiring someone like ourselves to do this thing for you. And it's the same thing for the trustee. They don't have to be an expert in everything, as long as they could seek qualified financial advisors, tax preparers, attorneys. That would be sufficient to make sure they could get the help they need. And these sort of help, when it's done for carrying out the trust purpose and the asset that the trust has, those are all paid by the trust. It's not paid by the trustee. And even if the trustee pays for it, the trustee would have the right to be reimbursed. We want them to be detail oriented. We want them to take the step that needs to be taken, compile a list of what the trust owns, track the income, the expenses. They have to file tax returns. The accountant is going to ask for these things. They have to provide that kind of information to the beneficiary. And failing to do what is required can lead to conflicts and legal action against the trustee and getting them involved and getting them in trouble. We want them to be organized. Trust can be challenging to manage, and that's because there's usually complicated assets in there. There could be a lot of beneficiaries. There could be distribution plans in there that are complex. There are different stages. There are different things that is required from the trustee to do. So it really is helpful if the person you're going to select is someone that is organized. And we definitely do not want them to mix any of their personal asset with the trust account. So in no shape or form, if you're a trustee, you should take money from the trust asset and deposit it into your personal account. It always helps if they're a good communicator. As I mentioned, they have to communicate with the beneficiaries. And if they could communicate in such a way that the beneficiary understand what's going on, it would realistically lessen the chance of lawsuits and those sort of things. Trustees act in the best interest of the beneficiaries, must make sure the beneficiary understand what is going on. We really want them to answer their question, provide information in a timely manner. And it's always good if they get along with the beneficiaries. All right. And we also want them to follow the rules. There are 3 sets of rules they have to follow. One is state law rules. For example, in California, property taxes and property assessment and those sort of things are huge. And when somebody passes away, when a trustee changes and you got a new successor trustee, a lot of times there are state law as it relates to property taxes that needs to be followed, and certain form needs to be filed. There are certain notices. California has 16061.7 notice that is required to be given to beneficiaries by the trustee. There are federal laws. These are mainly related to tax laws and step up in bases and capital gain taxes and those sort of thing. There might be a state tax return needing to be filed if the value of the state is at a certain amount. Believe it or not, California does not have a state estate tax, but there is federal estate tax, and that may be an issue. So there would have to be some sort of a tax return filed. And always the trust itself, the instrument itself, has instructions in there, and it requires the trustee to follow those things. Trustees can sometimes use their own discretion. It's limited. It may be that, let's say there is a particular property within the trust, they can choose to sell the property if it's not generating enough income. They may choose to sell the property because it's just getting really old and it's requiring constant, things to be fixed. They may choose to use other property that the trust has to fix this property. So those things, if they're not specific instruction in the trust, then the trustee could do those things. However, often that is not the case, and there is specific instruction in the trust that requires the trustee to follow those. Let's talk about trustee options. Probably one that is used most often is family members. A lot of times spouses one spouse names the other spouse, or if we have a joint trust, when one spouse passes away, the surviving spouse becomes the sole trustee. Children, parents, siblings, those are often trustees or they at least are appointed as trustees. One good thing with having family member as trustees is that in most cases, they understand your wishes. If you name a trustee, if a trustee is also a beneficiary, they can opt out of being compensated. When you're a trustee, you would most likely have the right to be compensated for your services. The services that you receive, or the compensation you receive for the services you've provided, that is a taxable income. That is an income. That is not an inheritance. So sometimes if I'm the beneficiary and I'm also the trustee, if I choose to waive my compensation and receive now a higher inheritance, the inheritance would most likely, the inheritance will escape any income taxes. So that's why sometimes it may be a good decision if you're the beneficiary, particularly if you're the only beneficiary, to waive any compensation. And sometimes if you're a trustee of your own trust, so if you're a beneficiary, there was a subtrust or a continuing trust created for you, having you being the sole trustee of your own trust may be problematic with asset protection. There are ways to sort of get around this. The other option is close friends. Again, same thing. They probably understand your wishes and your values. However, sometimes they don't want to get involved in family conflicts. They may want to be compensated and may cause a conflict between trustee and family. So that's some of the pluses and negatives for close friends. And then the third one, you could hire professional trustees. Believe it or not, this is actually a career. There are companies that with all they do is they act as a fiduciary. They act as a professional trustee. And the great thing about them is it provides the maximum protection for inheritance because these guys know exactly what to do. They're versed in trust administration process. And they're going to require to be compensated. One thing that sometimes the reason that people shy away from professional trustees is that they don't know you. They don't know the family. They don't know the dynamics. So that's, could be considered a negative for a professional trustee. That is the webinar. I hope you enjoyed it. I hope I was able to give you one thing that you didn't know. If you're interested to learn more about trust and estate planning and everything that is related to that, please follow me on the social media channels that we have. If you're looking to schedule a free call, please go to our website, talailaw.com, right here. And right on the first page, there's a button to schedule a free call with me. I'll be more than happy to see what I can do for you and your family. I'm hoping that you could sleep a little bit better at night after you get your trust done. All right, have a good one. Take care.